You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome back, listeners, to another episode of People, Places, Planet. I'm your host, Sebastian Duque Rios, and I'm excited today to continue our Explain series where we break down the United States fundamental environmental laws. In today's episode, we're going to be going over the Toxic Substances Control Act, or TSCA, which gives the Environmental Protection Agency broad authority to regulate new and existing chemicals in the United States. Today, I'm joined by Lynn Bergeson and Bob Sussman. Lynn is the managing partner of Bergeson Campbell and has earned an international reputation for her deep and expansive understanding of TSCA. Bob Sussman is currently the principal at Sussman Associates, following a long career as a prominent private practice attorney and senior official at EPA. Very excited to welcome both of you to the episode. Very happy to have you here.
Thank you, Sebastian. It's lovely to be here.
Yes, absolutely.
And to start us off, I'd love to hear a little bit more about your work and your connection to TSCA and toxic chemicals.
Well, I've actually been working on TSCA issues for almost my entire career, and I got into TSCA as a very young lawyer right after the statute was enacted in 1976, and much of my work for the next 10 or 15 years was under the old law. I was representing the chemical industry, and so I saw the progression of TSCA up front over a couple of different administrations. Then I went into EPA, and TSCA was not a particularly big focus while I was at EPA. I was actually at EPA twice in my career. However, when I left EPA the second time, I picked up on TSCA by starting to work with a coalition of NGO groups who were organizing and advocating for amending and strengthening the law. And so that gave me a bird's eye view of the creation of the new law, why it was put in place. And then once it was enacted, my focus since then has been representing NGO groups on the implementation of TSCA, and now again, on the legislative side, as there's once more renewed interest in TSCA amendments.
Bob, you are so modest. Your career, you have an extraordinary career, and you've witnessed TSCA from all sides of the equation, implementing it, representing private industry before federal agencies. I've learned so much from your understanding of TSCA. It's probably one of the reasons I was drawn to the field. As I was chatting with Sebastian before we began, I started my career doing Superfund and RCRA and made a hasty retreat when I stumbled upon TSCA as a young lawyer here in Washington. And for reasons that I can't fully explain, I've always been drawn to the law because of its fascinating intersection with public policy, public health, science, and law. It's the perfect storm, as it were, with the intersection of all of those interests and all of the stakeholders that come to the table in addressing TSCA. So I've been very fortunate to have a law firm that focuses on the law, TSCA, and other chemical statutes like the pesticide law, FIFRA. We have a very interdisciplinary team of professionals because I think it requires toxicologists, chemists, exposure assessors, and others. And it's been a fascinating career to practice in. And as you say, Bob, there's been a resurgence of interest in TSCA, certainly since Lautenberg. And currently, given some of the issues that we now see need to be addressed, whether administratively or legislatively, there's no dearth of interest in how TSCA is implemented and its effect on both domestic economies and global economies.
Fantastic. Thank you both. It's really such an honor to have you both here. And you're absolutely right that I think there's a really big relevance today. But to get us started, could you give us a quick primer on TSCA? Why was it created?
Yeah, let me take that and get started. Why was TSCA created? You'll all remember that the 1970s and late 1960s was the era of incredible legislative activity on the environment. We saw many of the major laws that have endured over the last 50 years put in place in that early period. But those laws initially focused on specific problems like air pollution, water pollution, disposal of hazardous waste, and record cleanup of abandoned waste sites through Superfund. And all of those laws really involved chemicals because, after all, pollutants are almost universally chemicals that find their way into the environment. But people began to realize in the 1970s, the first part of the 1970s, that there was really no law on the books that focused specifically on chemicals, on chemical risks, and on the life cycle of chemicals from production and manufacture to use and ultimately to disposal. And at the same time, there was a great deal of concern about the risks of chemicals, not just from air pollution or water pollution, but from the use of chemicals in consumer products and in various parts of industry. And so for that reason, there was a strong push to put in place a program that was specifically targeting chemicals, not water pollution or air pollution, but chemicals, chemical risks, and the entire life cycle of chemicals. And so that led to the enactment of TSCA in 1976. And the hope was that EPA would be focusing on the high-profile chemicals that were embedded in the economy and our society and widespread in our environment, and would look at those chemicals on a comprehensive basis. And that would involve understanding their toxic effects, assessing their risk, but also tracking the chemical through its life cycle and identifying the uses of the chemical and related activities that were big drivers of risk. And then using EPA's regulatory authority, trying to regulate the chemical holistically to eliminate the risk. TSCA, it filled a very big gap in the legislative universe, and it also addressed an issue that many Americans were concerned about and still are concerned about, which is the pervasiveness of chemicals in our society and the big question of whether the use and exposure to these chemicals is safe for workers, for consumers, and for communities. So that's why TSCA was born.
All the points you make, Bob, are spot on. I did a little poking around trying to get a sense of when was there actual legislative action early on, and I was surprised to hear that as early as 1971, there was an early legislative version of TSCA. And in 1971, also CEQ, the Council on Environmental Quality, issued a report that outlined many of the very points that you've just made, that the other media-specific laws were jurisdictionally limited to air or water. RCRA, of course, came out the same year as TSCA, 1976, but I suspect there was consideration of waste management issues floating around at that time, too. The only other observation I'd like to add is how I think at the time, TSCA was considered quite forward-thinking and perhaps quite special in, to use your language, its holistic approach to a life cycle approach to the management of industrial chemicals, which was a relatively, I think, at the time, novel and forward-thinking concept. So I don't often consider the early days of TSCA in 1976. At that time, there was a lot going on in the country. Ford signed into law, having taken over the presidency from Nixon, who had resigned in 74. There was an awful lot of focus on environmental contamination. Love Canal was still in the forefront in the early 70s and mid-70s. John Quarles, then Deputy Administrator of EPA, gave some testimony on other environmental contamination issues, including CFCs, PCBs. There was the Hopewell disaster in Virginia involving DDT-like pesticide that was discarded, causing all kinds of contamination. So there were a lot of various events going on nationally that drove people to be more focused on chemicals, not at the end of pipe stage, but much earlier in the process. And it's just interesting to think of TSCA being as novel, creative, holistic, and forward-thinking as it was back in
Well,
76.
yeah, I agree with all of that. And it's actually fascinating to go back and read the pretty extensive legislative history of the 1976 laws. And there's a sense of urgency and great concern about chemicals. And you read the legislative history and it talks about, boy, it's hard to do anything in our society without confronting chemicals. They're pervasive. They're part of our way of life. And yet we know much less than we should know how chemicals affect people, how they affect the environment. There was a lot of concern about the knowledge gap, that we had chemicals that were produced in hundreds of millions of pounds a year and were distributed throughout our society, but we didn't really know what we needed to know. We didn't really know whether they caused cancer or birth defects or were persistent or built up in people. And so from the legislative history, you get a strong demand from the Congress for information and knowledge about the effects of chemicals, and also a sense, if I can be a little dramatic, that Americans were the passive vessels, if you want to put it that way, for chemicals that were in their lives through the food that they ate and the products that they used and the places where they worked. This sea of chemicals, as it was called, which was considered ubiquitous, was beyond our control because we didn't know what their effects were and we had no ability to keep them out of commerce or regulate them when they were posing risk. You read the legislative history of TSCA and the sense of urgency is immense. The dimensions of the problem, as it's described in the legislative history, are very great and very extensive, and therefore the expectation for a comprehensive approach to chemical evaluation, chemical testing, and chemical regulation, the expectations were huge.
And if we're going to talk about expectations, I want to maybe also point to one more part of the legislative history that I think you all mentioned, which is the Lautenberg Amendments. And so could you tell us a little bit more about what drove the passage of the Lautenberg Amendments?
I think the Lautenberg Amendments were driven by a strong and pretty widespread sense that the expectations were not being met, and that the law passed in 1976 was a failure, which accomplished far less than people wanted, and so that drove consensus from different constituencies that we needed a better law, we needed more activity, we needed more protection, we needed a stronger agency. And that's where the Lautenberg Amendments came from. And these amendments, it's remarkable to keep in mind that these amendments were 40 years, basically, after the enactment of TSCA. So the old law, which most people would say now is a failure, was actually in place for 4 decades.
Maybe we can, for the benefit of the listeners here, give a little background on the structure of the original TSCA that was enacted into law in 1976. I think, Bob, you and I would agree that on paper, it seemed to hit all the right points. It authorized EPA to require chemical testing. It required pre-market review of new chemicals, defined as the law does define new chemicals, and requires EPA to review new chemicals to ensure that they meet a safety standard. It authorized EPA to regulate existing chemicals. And as we know, at the time, after EPA created the TSCA inventory, there were some, Bob, 62,000 existing chemicals in commerce, just thousands and thousands of chemicals. It required certain record-keeping and reporting obligations, many of which are still very much current today and provide EPA much needed information on the quantities, the toxicities, the uses of chemicals that are either imported or used in the United States. It regulates the import of chemicals and the export of chemicals. So structurally, TSCA, when it was signed into law in 76 and EPA thereafter began the process of implementing regulations to carry out the objectives of the law, made a lot of sense. At least pieces were there, Bob. And I know you saw it at the time from a different perspective as you implemented the law in your position at EPA. But on paper, it seemed like a good idea at the time. But I would agree with you that as time marched on, and 4 decades later, when Lautenberg was signed into law in 2016, there was a very vigorous debate leading up to the enactment of Lautenberg as to what went wrong. And it was a combination of failed implementation measures, some judicial decisions, corrosion proof fittings. The EPA's focus was not initially on existing chemicals as much as it was on creating the TSCA inventory and implementing the Section 6E PCB rules. So there were high expectations, a good working start. Structurally on paper, everything seemed to be but it just didn't get to where it needed to be. And that's why Lautenberg, 4 decades later, was so badly needed to address these deficiencies and perhaps clarify to a much greater extent what EPA's authority is and is not under the law.
So based on what you're saying, Lynn, it's evident that the structure was there. Testing authority, pre-market review, the power to regulate chemicals found to pose an unreasonable risk to human health or the environment, all the ingredients of a strong law. But as you said, 4 decades passed before Congress felt it needed a major overhaul. In practice, how much did EPA actually use those authorities, and did the law deliver on its promise?
Yeah, I think the biggest failure here is epitomized by the question that was asked repeatedly during the development of the Lautenberg Act, which was, so EPA, you've been implementing this law for 40 years. How many chemicals have you banned? How many chemicals have you restricted? How much risk have you reduced? How much disease have you reduced by reducing exposure to chemicals? And the answers were, I think, embarrassing, because in that 40-year period, only a small handful of the 60,000 existing chemicals that were in commerce were actually restricted. And a lot of the restriction which occurred related to PCBs. And the reason why EPA addressed PCBs was that Congress wrote into the law very prescriptive requirements that called for the end of production of PCBs and their elimination from many activities throughout the country where PCBs were being used. The thing about that is it only occurred because there was a strong hammer in the law that made it occur. And apart from PCBs and maybe 1 or 2 other classes of chemicals, the law looked to EPA to use its discretion and authority to identify risks and then to deal with them. But EPA made very limited progress. And one reason actually is that while the law seemed in principle to be very strong and very far-reaching, there were various burdens that were put on the EPA, the regulatory process, that the agency struggled to overcome. And that inability to overcome the obstacles in the law was very vividly apparent in 1991 court decision that set aside EPA's prohibition on asbestos. This asbestos rule was years in the making. It reflected a mountain of evidence that asbestos was dangerous and, in fact, causing the deaths of tens of thousands of people in the U.S. and around the world. And so EPA decided this is a classic situation that calls for the application of a holistic life cycle approach. We'll go after not only the importation of asbestos fibers, but all the various uses of asbestos throughout the economy, and we'll ratchet down the risk. The problem was that the industry, and actually other countries like Canada that mined asbestos fought very hard against this ban and ultimately went to the Fifth Circuit Court of Appeals, and the court threw out the asbestos ban. And I think at that point, all of the air went out of TSCA because people, including the agency itself, realized that this was a tough law to implement. And it required EPA to jump through a number of hoops that took a lot of time, required a huge amount of analysis, including cost-benefit analysis, and in the end gave opponents of EPA regulation rich targets to shoot at in the courts. So after the asbestos decision in 1991, I think that no existing chemicals were regulated under TSCA.
No, exactly right, Bob. And I want to make sure listeners are not of the view that EPA was just sitting on its hands for 4 decades. It was building the TSCA inventory, reviewing and approving new chemicals, working on other aspects of the law. But to your point, Bob, I think there was a growing sense in 1989 when the final asbestos rule came out, and then the final Fifth Circuit decision invalidating and vacating the provisions of the rule that banned uses of asbestos. It was dispiriting for everyone, most especially EPA and the Department of Justice, given such a terrific loss, that if you can't ban asbestos, what the heck can you ban? What kind of law is this? That was the sense at the time. And you're right, it took the wind out of the sails of the agency and blunted any other rulemaking initiative that would have sought to apply the Section 6 standard of demonstrating the least burdensome option for addressing the unreasonable risk found when an existing chemical is subject to review under Section 6. So there was also growing frustration, probably writ large, with TSCA's implementation throughout the 90s, leading ultimately to the conclusion that this law is just not doing what it was intended to do, certainly with respect to existing chemicals. And again, the statute was well-intentioned, right? It purported to give EPA the authority to regulate chemicals found to pose unreasonable risk to human health or the environment, but without some sort of blueprint for how best to address the 62,000 and now growing number of existing chemicals. All those years later, from 76, the inevitable conclusion was this dog won't hunt. It's just not working as intended.
That's a pretty striking indictment, a law that sat largely dormant for 40 years. Was this more of a failure of the law's design or EPA's implementation of it? Or was there something about how TSCA compared to other environmental statutes that made it particularly difficult to enforce?
There's one critical difference between TSCA and other environmental laws, which may not have been focused on at the time TSCA was enacted in 1976, but over time became very important to understand whether TSCA was succeeding or failing. And that is that other environmental laws are very prescriptive. They set very specific goals for EPA. They demand action by very specific deadlines. They empower the courts to issue orders requiring EPA to meet deadlines if they miss them. And some of the laws, in essence, prejudge the seriousness of problems that EPA is working on. The Clean Air Act is a classic example of that because it basically says to the agency, here are the priority pollutants, here are the pollutants that most threaten the health of Americans, and these are the pollutants that you need to work on, and here's how you need to do it. TSCA was much more open-ended than that, and I think that was part of the problem. I guess you might want to blame EPA for not being more proactive, more adventurous in meeting the law. But I would say, based on my own time at the EPA, that EPA gets a lot more done if Congress has been prescriptive and given EPA deadlines and clear goals, and we didn't really have that with TSCA. The other thing that lay at the heart of TSCA, which probably should have been discussed more fully at the time the legislation was passed, was that Congress made TSCA, or at least the Section 6 of TSCA, regulating existing chemicals. It made the law a cost-benefit statute. In other words, it explicitly called for EPA in regulating chemicals to quantify the costs of regulation and quantify, if it could, the benefits of regulation and demonstrate that the costs and the benefits were in balance. And that seems like a good idea. And indeed, from a theoretical standpoint, economists think that cost-benefit analysis is the way decisions should be made. But cost-benefit analysis requires an incredible amount of information, both on costs and benefits, and it creates lots of opportunities for debate about, has the agency really nailed the costs? Are the benefits of the rule really significant? If the costs are in the millions of dollars and it's hard to quantify the benefits, can you really justify the rule? And those are questions that made it tough for EPA and slowed down implementation. And then in the court decision in 1991, the court more or less held EPA accountable for not properly balancing benefits and costs and threw out the rule. And many people look at that and said, gee, if there's ever a chemical for which the benefits of regulation are huge because so many people are dying from exposure to asbestos, that chemical is asbestos. And if you can't say that the costs of the rule are outweighed by the benefits for asbestos, when can you say that for any chemical?
Exactly right.
Now, we've touched on some of the specific provisions of the law, sections 4, 5, and 6, covering testing, new chemicals, and existing chemical regulation, respectively. But it sounds like on paper, those authorities looked a lot more functional than they turned out to be in practice. Lynn, what actually needed some fixing or tender love and care under the original statute?
One of the policies of TSCA, Bob, as you know well, is to ensure that EPA has adequate information that it has available to inform its judgment as to chemical risks and how best to address them. Section 4, the chemical testing provisions of original TSCA, were pretty difficult to implement. If I recall correctly, there were a lot of test rules that were subject to challenge. EPA did not have, as it does now, unilateral authority to compel chemical testing, which is an important part of the equation. So Section 4 was pretty materially flawed. Section 6, for all the reasons we've been talking about, was not working as intended. Section 5, the new chemicals program, I know you and I disagree on this, Bob. There is a perception that from many of my clients that Section 5, new chemical review, was working well and as intended. But the law in 2016, Lautenberg, significantly revised the standard for chemical approval and has made new chemicals subject to much more regulation and restriction.
That's a big shift in how the burden falls, going from 10% of new chemicals facing any restrictions to 90% under Lautenberg. And you mentioned the 90-day review window that often stretches much longer in practice. So it sounds like while Lautenberg strengthened protections, it's also potentially created new friction for the chemical innovation pipeline. What was the broader pressure building in the years before 2016 that finally pushed Congress to act? Were there forces outside of EPA that helped build the case for reform?
In addition to these structural flaws with the original TSCA, there were lots of other things going on nationally, right? Prop 65 was implemented in 1986, so there was much greater awareness of the presence of carcinogens, of reproductive toxicants, and products known and distributed widely in commerce. REACH, the European counterpart to industrial chemical regulation in Europe, was in full force and effect by 2007. A different approach to chemical regulation, but one that was thought to be more aggressive and perhaps more effective than what was going on here in the United States. There was an abundance of state chemical laws that was filling in the void left by an ineffective federal chemical statute, that would be TSCA. So for a whole lot of different reasons, there was eventually, not early on, but eventually a consensus that TSCA needed to be legislatively revisited, which gave rise to lots of different legislative suggestions starting in probably 2013, 2014, leading up to 2016's eventual passage of the Frank R. Lautenberg Chemical Safety for the 21st Century Act.
Those are all great points. And it's important to roll back the clock to 2010, the years leading up to 2016, because we had a different public environment, different political environment, different set of perceptions on the part of the public about chemicals than we may have now, and certainly had in the early years of TSCA. And one of the things I wanted to emphasize is that there was strong grassroots energy and activity around chemicals coming not just from the few major national environmental organizations, but by groups that were regionally based or state-based that had particular areas of interest and focus and represented a strong constituency for proactive chemical regulation. And as Lynn mentioned, one consequence of that was that states became very active in the chemical space and in many ways were leaping ahead of EPA and putting regulations in place that went beyond anything that EPA was doing in TSCA. And I think it's also fair to say, Lynn, if you agree with this, that the industry had a perception that the law was not working in their best interests, and the credibility of the industry was being damaged by the lack of an effective environmental law. At the same time that industry was worried that it would have to deal with a decentralized, state-driven system that put burdens on interstate commerce and sent very conflicting signals to companies.
No, I totally agree with that. Not only was there the reality that 50 different states could and were enacting very disparate approaches to chemical management within their borders, that caused a lot of commercial disruption. But to your point, Bob, I think there was a growing perception that there was a loss of confidence in EPA's ability to assure the safety of chemicals in not only consumer products, but just chemicals that are marketed generally in the United States. So stakeholders across the board at different times gradually came to the consensus position that TSCA needed very significant legislative change to reset the record, give EPA different authorities to ensure that the 1976 deficits in those areas that were very clearly broken could be fixed. And here we are 10 years after Lautenberg was enacted, as we are recording this in mid-May of 2026. There's a lot of discussion now about how well did we do in fixing the problem and what remains to be done, or what should EPA be doing differently in implementing the law.
And it sounds like those pressures, the state patchwork, the loss of public confidence, the contrast with Europe's REACH framework, were really what finally broke the logjam after 40 years of stalled reform. Lynn, from where you were sitting at the time, what was the tipping point that brought industry, NGOs, and both parties to the same table?
I think there was growing recognition that TSCA structurally was not up to the job of providing the confidence and assurance that U.S. citizens and others wanted and needed with regard to chemical safety. So just the loss of confidence in a federal law that was intended to ensure the safety of chemicals marketed in the United States. There was the commercial implications of differing state laws that would impede and make life quite miserable for chemical manufacturers, processors, and distributors, and manufacturers of products that contain chemical components if labeling and risk standards and restrictions were as disparate as they were becoming, whether they were state chemical laws or product-specific laws relating to children's toys or jewelry or other articles that have a significant chemical component. So that recognition that just marketing products, manufacturing products, processing products in the United States was becoming increasingly hampered by a diversity of state and even local restrictions on chemicals. There was also the threat of consumer and other backlash with regard to tort liability, product liability for chemicals that were perceived to be insufficiently regulated to ensure products did not pose risk to either human health or the environment when used as intended. And as I mentioned before, there was the contrast of the European industrial chemical law that was quite different, both in defining what risk is. It's more hazard-based as opposed to risk-based. What data should accompany chemicals when they are marketed, both new and existing. So the contrast between the EU REACH paradigm and the TSCA paradigm under the existing law was pretty significant, which gave rise to inferences, all of which that could be adverse to chemical manufacturers, processors, and others of the domestic chemical community. So I think all of those concerns drove industry to the conclusion that we need to get serious about fixing TSCA, bringing it up to current standards, and creating a law that could be implemented in a way that addressed some of these structural deficits. That was my perception in the, pre-Lautenberg days. You might have a different perspective. I think industry didn't come to that conclusion as quickly as some would like, but ultimately people got there.
Yeah, I would not disagree with that. And we talked about the failures of the original law and the unfortunate reality that very little happened. There was very little regulation of chemicals. What we had, like the asbestos rule, could not survive review in the courts. And so if you pass forward to Lautenberg and look at the law, many of the things in the law were really designed to fix those problems. For example, the law gave EPA clear targets and deadlines for evaluating chemicals and then regulating them, and that was an effort to put EPA under the gun so that if EPA didn't meet the requirements of the law, the courts could step in and enforce those requirements. And then also in Section 6, a cost-benefit analysis was taken out of the equation so that the decisions that EPA made would be risk-based. That is to say, there would be no balancing of risk considerations against economic considerations. And that was a clear reaction to the asbestos decision. I think that the industry understood that they needed a credible law to legitimize their chemicals and products in the eyes of the public. But of course, saying in the abstract that you want a credible law is different from the reality of EPA regulating a lot of chemicals, including chemicals that make a lot of money for the industry and are pretty embedded in the economy. And so that's sort of where the rubber meets the road and met the road in the case of the Lautenberg Act, and is an important issue in understanding where we are now.
You've done a great job weaving the statutory framework into the history as we've gone. Before we move on, I want to make sure our listeners have a clear answer to a fundamental question. What chemicals does TSCA actually regulate? We have FIFRA covering pesticides, the Food, Drug, and Cosmetics Act covering FDA-regulated products. So where does TSCA's jurisdiction begin and end? And relatedly, can you walk us through what the review process actually looks like in practice when a new chemical comes to the market?
Of course, we have a number of regulatory laws in place, and we had those laws back in 1976 when TSCA was passed, and we still have them. And so the law does not give EPA complete and unlimited authority over chemicals. So pesticides are not covered. They have their own law. FIFRA, Food, Drug, and Cosmetic products are not covered. They're regulated by the Food and Drug Administration. And there's also, I think, an overlap between TSCA and OSHA as an example. OSHA regulates the workplace, develops health standards that apply to chemicals, and EPA occupies that space too. But it does, at least in theory, overlap with OSHA. The boundaries are often not very clear, and certainly there are large classes of chemical uses that EPA cannot address under TSCA.
When we describe the jurisdictional divide between and among the universe of chemicals, Sebastian, we usually urge our clients to think of three big buckets. So there's the industrial chemical bucket, which is regulated by TSCA, intentionally very broadly defined by Congress. Then there's the pesticide bucket under FIFRA, the Federal Insecticide, Fungicide, and Rodenticide Act. So if a chemical has a particular potency that is intended to kill, destroy pests, it's in that bucket. And then the third bucket is the Federal Food, Drug, and Cosmetic Act, as Bob defined, those chemicals that have a particular use or application that is expressly defined under the FFDCA and regulated by FDA. There are other outliers. There's nuclear stuff, there's tobacco products, but the three big buckets include those three. And TSCA is very large. Chemicals can have different uses. They can be used as a pesticide. They can be used as an industrial chemical. They can be used in FFDCA application. So you have to be very careful what jurisdiction applies, and it's very dependent upon what you intended to do and what is the functionality of the chemical that is under review. You asked about new chemicals. That Section 5 of TSCA addresses new chemical substances. You might say, what's new? What's a new chemical? Well, new chemical is defined to include chemicals that are not listed on the TSCA inventory. And this is not a master class in new chemical review, but one of the big changes in Lautenberg was to address new chemicals differently than they had been addressed under the original law. So under the new law, as of 2016, EPA, unlike its predecessor, was required and is required to make an affirmative finding with regard to each chemical, whether or not the chemical presents or may present an unreasonable risk or it is not likely to do. So that was a huge change. The legal standard EPA looks to is if it does present an unreasonable risk or is likely to present an unreasonable risk, EPA has to address those risks by restricting the new chemical. Under the old law, I think maybe 10%, Bob, of chemicals that were subject to pre-market review by EPA under the Section 5 program, about 10% of those were regulated, meaning that there were restrictions applied through a significant new use rule to abate whatever unreasonable risk was presented by that chemical under that review. Under Lautenberg, the ratios have flipped, so roughly 90% of new chemicals are subject to some sort of restriction depending upon what the use is and what the chemical is and what the review elicited in terms of whether that use posed unreasonable risk under its normal conditions of application. So it's been a very significant change in the way EPA must make an affirmative finding, how that finding is recorded in the recordation of the review of the chemical, and what restrictions apply to new chemicals. Under the statute, the review period is 90 days, but we all know it was many more days than 90 under old TSCA and considerably longer under new TSCA, which has been a point of considerable frustration by the chemical innovators here in the United States or elsewhere. There's lots and lots of reasons why that review is as robust and as long as it is. Some of them unforced errors by EPA, others just interpretive issues that have been the subject of vigorous debate over the past 10 years. We're going to talk a lot about this at our TSCA 10 Years Later conference because Section 5 review has been the subject of very vigorous debate. Not everyone agrees on what needs to be reviewed, how long the reviews are, and whether foreseeable uses are legitimately or appropriately defined by EPA during the PMN review process.
That's a really useful breakdown of the new chemical side of the equation. And it sounds like 10 years in, what seemed like a rare moment of consensus with industry, NGOs, and both parties aligned is starting to show some fault lines. Bob, where do things stand now?
That's right. And just to take a step back here, it is interesting that here we are 10 years into the Lautenberg Act and the really impressive and unique bipartisan consensus that pushed that act to be enacted and brought together industry and NGOs and Democrats and Republicans, at least for a brief moment of agreement. Now, 10 years after that moment, we see very different perspectives on TSCA. The industry is very concerned that the new chemical process in particular is harming innovation, and they're saying that process needs to be streamlined, that EPA's actions on new chemicals need to be accelerated. But on the other hand, the environmental community believes that while TSCA has achieved some success, it's been disappointing. The Lautenberg Act has been disappointing in some respects. And the last thing we want to do is take a law that is perhaps just getting started and to weaken it before we've really had an opportunity to see what it can accomplish. We moved from a world of great consensus 10 years ago to a very different, more polarized world right now.
One little footnote there, Bob. I think a lot of people would like to see things done differently under TSCA. Whether legislative change is necessary, people will disagree. Whether administrative refinement or clarification is necessary, I'm not sure I would necessarily consider it weakened, because there are lots of terms and approaches and interpretations of the language in Lautenberg that has given rise to extraordinary debate and frustration. But I'm not sure I would use the term weaken as much as we need clarification, whether that clarification is coming from Congress, certainly coming from the courts. We need clarity and closure on some of these issues if we're going to keep the ball rolling with regard to chemical review, particularly with respect to existing chemicals, because we seem to be taking one step forward and two steps back in ways that are not necessarily contributing to public safety or chemical safety.
Yeah, that is the perspective of some in industry. And I think, unfortunately, it's fair to say that proposals that have been surfacing in Congress, discussion drafts of legislation that have been produced both by the House and by the Senate, do contain some very significant rollbacks, at least from the perspective of many Democrats and also from the perspective of the environmental community. We hear a lot of discussion about whether the legislative proposals do represent weakening of the law. There's certainly a strong school of thought that they do. And there's also a school of thought that, as Lynn reflected, the goal is not so much weakening the law, but making it work better. So whether we can get alignment on those issues and produce a new TSCA, I think is really open to question. But certainly we have an interesting and thought-provoking debate underway.
Which is somewhat time limited, Bob. One of the reasons why this debate with regard to legislative change has evolved is because of the forthcoming expiration of EPA's ability to get fees associated with certain affirmative actions that it undertakes under TSCA. That authority lapses this September. So I don't know what your sense is of putting your prognostication cap on. There's House discussion drafts, Senate discussion drafts. Will TSCA be amended before Congress adjourns this year?
I would say that it's a real long shot, and I'm not sure that we're going to see the political will and the degree of bipartisan consensus that we need to move legislation. I think the prospects are uncertain at best. Perhaps there are others who have a different view.
Hope springs eternal. There are opportunities, but yeah, the window is closing. And again, we have a wonderful discussion about legislative changes to TSCA that are pending at our TSCA at 10 program on June the 10th. So we hope listeners who are interested in the legislative side of the equation will be tuning into that very lively discussion on June the 10th.
And before we begin wrapping up, I wanted to ask you both a little bit more about the enforcement of TSCA. I know we talked about how implementation was a really big challenge prior to the amendments, and I'm curious, what does compliance and enforcement look like for TSCA? And what kind of penalties do actors face if they fail to meet the statute's requirements?
Yeah, I think the short answer to that question is there is not any serious enforcement that is now happening at the Trump EPA. It's not just a lack of action under TSCA, it's a lack of action under other environmental statutes. So I think if you talk to many people in industry, they will say that enforcement is not a big concern because there really is no enforcement at this point of time. We actually think that given some of the rules that have taken effect under TSCA, some of the existing chemical rules under Section 6, there is non-compliance which is occurring. In working with my clients, we have filed citizens enforcement cases against companies for violations that we thought were pretty clear cut, in which companies actually agreed had occurred. And so there are enforcement needs that are not being met right now. And that's a concern that I think you're going to hear more about, not only under TSCA, but under other laws.
I have a slightly different perspective. To your point, Sebastian, EPA has broad authority under TSCA Section 11, subpoena power, administrative penalties, civil and criminal, under Section 17, specific enforcement authorities relating to seizure of goods and products. I think there is a perception that enforcement is down under the Trump administration. I can only speak to what I see, and we are very busy, Bob, in defending against EPA administrative actions involving both TSCA and FIFRA. All the usual suspects, Section 8 record-keeping reporting violations, similarly under FIFRA, violations of labeler requirements or import and export enforcement actions. So I know there is a perception that enforcement is down because of various EPA policies relating to compliance first and so on and so forth, but I just know my reality is quite different.
Lynn, that's really interesting because you're both describing the same landscape, but from different vantage points. And so, Bob, you're out there filing citizen suits to fill a void you say EPA isn't fully addressing. Can you tell us a little bit more about what that looks like?
We're very effective, but that's only because there are violations. And in virtually all our cases, we developed evidence of violations and we presented the evidence to the companies. And in almost every instance, we got a settlement with the company and they committed to comply with the law. Now, I will say that for every one of these cases, we sent notices to EPA as the law requires 60 days in advance of taking enforcement action. And I can only think of one instance where EPA was already targeting the company. But in all the other cases, we had a wide open playing field and EPA never took any action at all. And of course, under citizen suits, you can only really compel the company to comply with the law. You can't collect civil penalties for past violations. So even though we achieved settlements, there was still the issue of past non-compliance and assessment of penalties. And in no instance did EPA do that.
There are always going to be violations. It's often, from my perch, a question of will EPA put boots on the ground or conduct an audit or a paper desk audit to determine if there are actionable violations that will result in some sort of administrative action. And call me crazy, but we see an awful lot of action these days under multiple provisions of TSCA and a like number under FIFRA, which surprises many of our clients because they expect a different response from EPA's Office of Enforcement and Compliance Assurance. And to your point, Bob, there has been an uptick in Section 20 actions filed by citizen activists. And that's their right. Your client is very effective at doing its job. You're right that EPA seldom tries to preempt those actions. There seems to be plenty of work for everybody in this area, but I haven't seen a diminution in enforcement. It's not at all what I expected. And Sebastian, you asked about penalties. They're high. TSCA is notoriously high. The typical statutory max right now under TSCA is $49,772 per violation based on EPA's 2025 inflation adjustment rule. And it will go up each year to track inflation, which of course is creeping up. But TSCA penalties are notoriously high because of the per day statutory max. There are opportunities to negotiate a smaller value, but the agency enforces the law in a way that gives rise to very significant penalties, which is why trying to make sure that you are compliant with TSCA is in your company's best interest.
And it's worth noting for listeners that TSCA also has public comment periods built in. So whether you're a researcher, a practitioner, or just an engaged citizen, you can submit data, flag concerns, or weigh in on proposed rules. That's a meaningful lever for anyone following these issues closely. Lynn, on that note, you have the 10 Years of TSCA Reform Conference coming up on June 10th. Do you want to tell us a little bit more about what's on the agenda, especially anything that we haven't covered today?
Thank you, Sebastian, for asking about the TSCA Reform 10 Years Later Conference. It is a hybrid meeting. It is going to take place on June the 10th at the Jack Morton Auditorium on the campus of George Washington University here in Washington, D.C. We already have hundreds of registrants, but space is limited. If you wish to participate in person, there's about a 200-person limit, so we urge you to register. We have 5 different panel discussions on all the hot topics on TSCA. We've talked about many of them here. Panel 1 is on risk evaluation, what's working, what's not. Panel 2 is on risk management. That will include many of the ongoing litigations involving the challenge to EPA final risk management rules. We have a keynote address by Dr. Lynn Goldman will be both interviewing and introducing the Honorable Thomas Stewart Udall, former senator and former ambassador to New Zealand. Mr. Udall was, of course, very instrumental in Lautenberg, and he's going to reminisce about what led up to Lautenberg, what's working and what's not. Really looking forward to that. Then we have a panel on new chemicals. We talked a lot about new chemicals and why many in the chemical community are frustrated with Lautenberg's implementation and seeking ways to hasten the time frame to get new chemicals onto the market and with fewer restrictions that, in the view of many, are not necessarily needed. Then we have a very extensive discussion on 10 years of Lautenberg. Where are we? So we've selected a really wonderful faculty of people who were very active in the passage of Lautenberg 10 years ago and will be giving their thoughts on what's working, what's not. And then we're going to conclude the day with our panel 5, TSCA Reform Redux, Change Beyond Fee Authorization. Bob and I spoke, Sebastian, about what are the legislative opportunities to amend TSCA, opportunities that are available now but closing quickly because this is a mid-year election year and Congress will be focusing on other things come Labor Day. So we're hoping to have a robust discussion on June the 10th about what those legislative provisions are and what is their opportunity for success in Congress. And then Jordan Diamond, president of the Environmental Law Institute, gives some remarks at 4:30 and adjourned by 4:45. So it's a fantastic program. Our steering committee, which Bob and I co-chair, worked very hard on this program, and we're hoping we have well over 1,000 registrants, both in the room and listening up virtually.
Fantastic. Seems like a great event, and I'd certainly encourage any of our listeners who are interested to register, and I will put a link in the show notes.
And it's free. I hasten to add, and we're going to serve lunch at the meeting.
All right. Well, thank you so much, Lynn and Bob. It was absolutely wonderful having you both on the podcast today and learning so much from you all. It was a privilege.
Oh, the honor is mine, Sebastian, and it's always a pleasure to share the podium with Bob. Thanks so much for your interest in TSCA.
Yeah, it's been great being here. We covered a lot of ground. And thank you so much, both Sebastian and Lynn.
This has been such a rich and wide-ranging conversation, and I think anyone listening has come away with a much clearer picture of TSCA, where it came from, why it struggled for decades, and how the Lautenberg amendments tried to reset the foundation. We've covered everything from the legislative urgency of the 1970s to the landmark asbestos decision that took the wind out of EPA's sails, to the current debates over new chemical review timelines, existing chemical risk evaluations, and what Congress might or might not do before the fee authorization window closes this September. Lynn and Bob, you've both given us a masterclass in how law, science, politics, and public health intersect in the world of chemical regulation. It is very clear that TSCA is very much a living law, still evolving, still contested, and still central to protecting human health and the environment in the United States. For our listeners who want to go deeper, I'd encourage you to look into the TSCA Reform 10 Years Later conference on June 10th. The link will be in the show notes. If this episode resonated with you, I'd also encourage you to share with your colleagues and others who might be interested. And if you're interested in hearing more from People, Places, Planet, subscribe so you don't miss an episode. Thank you so much to Lynn Bergeson and Bob Sussman for joining us today. This has been People, Places, Planet. I'm Sebastian Duque Rios, and we'll see you next time.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.